What if one simple rule, something most Americans never even question, suddenly changed overnight? What if being born in the United States no longer guaranteed that you were American? This is not a hypothetical scenario anymore. It's a real, unfolding legal battle that could redefine the meaning of citizenship itself. On April 1st, 2026, the U.S. Supreme Court will hear arguments in a case that could shake the foundation of a 150-year-old constitutional principle. At the center of this storm is Donald Trump, whose controversial executive order challenges the long-standing interpretation of birthright citizenship. For generations, the idea has been simple. If you are born on American soil, you are an American citizen. It's a principle taught in schools, embedded in law, and accepted as a core part of national identity. But now, that certainty is under threat. This debate is not just about law, it's about identity, belonging, and the future of millions of people. Birthright citizenship comes from the 14th Amendment, adopted after the Civil War to ensure that formerly enslaved people were recognized as full citizens. Its citizenship clause clearly states that anyone born in the United States and subject to its jurisdiction is a citizen. For over a century, this has been interpreted broadly, meaning that even children of immigrants, whether documented or undocumented, are granted citizenship at birth. This interpretation was cemented in the landmark case United States versus Wong Kim Ark, where the Supreme Court ruled that a man born in San Francisco to Chinese immigrant parents was indeed a U.S. citizen. That decision became the backbone of modern citizenship law. But now, everything is being questioned. Trump's executive order argues that the Constitution has been misunderstood for decades. According to his administration, the phrase, subject to the jurisdiction thereof, does not apply to everyone born on U.S. soil. Instead, they claim it excludes children whose parents are in the country illegally or only temporarily, such as students or workers on visas. If this interpretation is accepted, it would mark one of the most dramatic shifts in American legal history. It would mean that thousands, potentially millions, of children born in the U.S. might no longer be recognized as citizens. As the case heads to the Supreme Court, tensions are rising across the country. Immigration has long been a deeply divisive issue in the United States, but this case takes the debate to an entirely new level. It's no longer just about who can enter the country, it's about who gets to belong. Civil rights organizations, including the American Civil Liberties Union, argue that Trump's order is unconstitutional and undermines a fundamental promise of equality. On the other side, supporters of the policy say it is necessary to prevent abuse of the system and to redefine citizenship in a way they believe is more consistent with the original intent of the Constitution. The stakes could not be higher. This is more than a legal dispute. It's a moment that could redefine what it means to be American in the 21st century. If the Supreme Court sides with Trump, it could rewrite over a century of legal precedent and change the lives of countless families. If it rejects his argument, it will reaffirm a principle that has shaped the nation for generations. Either way, the decision will echo far beyond the courtroom, influencing politics, immigration policy, and the identity of the country itself. And as the nation waits for the arguments to begin, one question looms larger than ever. Who truly has the right to call themselves an American? To truly understand why this case matters so much, you have to go back in time, long before modern immigration debates, long before political slogans, to a moment when the United States was redefining itself after one of the darkest chapters in its history. In 1868, in the aftermath of the Civil War, the nation adopted the 14th Amendment. This was not just another legal change, it was a powerful statement meant to correct a grave injustice. For the first time, it guaranteed citizenship to formerly enslaved people who had been denied basic human rights for generations. The citizenship clause within that amendment was written in clear, sweeping language. Anyone born on U.S. soil and subject to its jurisdiction is a citizen. At the time, this idea was revolutionary. It rejected exclusion and embraced inclusion, setting a foundation for what America claimed to stand for: equality under the law. But as history has shown, even the clearest words can be debated, challenged, and reinterpreted. Just a few decades later, the meaning of this clause was put to the test in the landmark case United States versus Wong Kim Ark. Wong Kim Ark was born in San Francisco to Chinese immigrant parents during a time when anti-Chinese sentiment was high and laws like the Chinese Exclusion Act restricted immigration. After traveling abroad, he was denied re-entry into the United States, despite being born there. His case eventually reached the U.S. Supreme Court, where justices faced a critical question: does being born in America automatically make you a citizen, even if your parents are not? In a 6-2 decision, the court said yes. That ruling didn't just decide one man's fate, it set a powerful precedent that has guided citizenship law for over a century. For generations, that decision created a sense of certainty. Immigrant families, regardless of their background or legal status, believed that if their child was born in the United States, that child would have a secure future as an American citizen. This belief became deeply woven into the American dream. It meant that even if parents struggled, faced uncertainty, or lived in fear of deportation, their children could still belong fully to the country they called home. It created hope, stability, and a pathway to integration. Countless stories of success, from business leaders to public servants, began with that simple guarantee: birth on American soil equals citizenship. But now, that certainty is being shaken. Donald Trump and his administration argue that the Wong Kim Ark decision has been misunderstood or applied too broadly. They claim it was intended to apply only to children whose parents had a permanent and legal presence in the United States, not to those who were undocumented or temporarily residing in the country. This reinterpretation challenges more than just legal precedent. It challenges decades of lived reality for millions of families. It raises difficult and deeply personal questions. What happens to children born into uncertainty? What does it mean to grow up in a country that may not recognize you as one of its own? The emotional weight of this debate cannot be ignored. Behind every legal argument are real people, families who have built their lives around the assumption that their children are citizens. Civil rights advocates, including the American Civil Liberties Union, warn that changing this interpretation could create a new class of individuals who are effectively stateless, born in the U.S., but not fully recognized by it. They argue that this would not only disrupt lives, but also contradict the very principles the 14th Amendment was designed to protect. As the nation watches this case unfold, it's becoming clear that this is not just a legal debate about words written over a century ago. It's a deeply human story about identity, fairness, and the promise of belonging in America. At the heart of this controversy is the executive order issued by Donald Trump, which attempts to redefine who qualifies as a U.S. citizen at birth. According to this policy, birthright citizenship would no longer automatically apply to children born in the United States if their parents are either undocumented immigrants or are in the country on a temporary basis, such as students, tourists, or workers on visas. In practical terms, this means that even if a child is physically born on U.S. soil, their citizenship status could depend on their parents' legal standing. The administration argues that this interpretation aligns with the phrase "subject to the jurisdiction thereof" in the 14th Amendment, suggesting that not everyone present in the country is fully under U.S. jurisdiction in a legal sense. This reinterpretation, if upheld, would represent a fundamental shift in how citizenship is determined in the United States. The scale of potential impact is significant. According to estimates referenced in the debate, there are millions of undocumented immigrants living in the United States, and many of them have children born on U.S. soil. Under the traditional interpretation of birthright citizenship, these children are automatically recognized as U.S. citizens, granting them access to rights such as education, healthcare, and the ability to live and work legally in the country. However, under the proposed policy, these same children could face uncertain legal status from birth. This could create a new category of individuals who are physically born in the United States but are not granted the full legal protections and identity that citizenship provides. Over time, this could affect not just individuals, but entire communities, reshaping demographics and altering the social fabric of the nation. One of the most debated aspects of the executive order is its potential to affect families differently depending on their immigration status. For example, if both parents are undocumented, their child would not be granted citizenship under the new interpretation. Similarly, if one parent is in the country legally but temporarily, such as on a work visa or student visa, and the other parent is not a U.S. citizen or lawful permanent resident, the child could also be excluded. This introduces a complex system where citizenship is no longer a simple matter of birthplace, but instead depends on a combination of parental status and legal interpretation. Critics argue that this complexity could lead to confusion, administrative challenges, and potential legal disputes at both federal and state levels. Supporters of the policy, however, argue that it addresses what they see as a loophole in the system. They claim that the current interpretation of birthright citizenship may encourage what is often referred to as birth tourism, where individuals travel to the United States specifically to give birth so their child can obtain U.S. citizenship. They also argue that limiting automatic citizenship could reduce incentives for illegal immigration. On the other hand, opponents, including organizations like the American Civil Liberties Union, contend that these claims are overstated and that changing birthright citizenship would punish children for the legal status of their parents, something they have no control over. They emphasize that citizenship has historically been viewed as a birthright tied to location, not parental eligibility. Ultimately, the real-world implications of this policy extend far beyond legal theory. It touches on education systems, healthcare access, employment opportunities, and long-term social integration. Children born under uncertain citizenship status could face barriers in accessing basic services, traveling internationally, or even proving their legal identity. For families, this uncertainty could create stress and instability, while for policymakers, it raises questions about enforcement, documentation, and fairness. As the U.S. Supreme Court prepares to hear this case, the outcome could determine whether birthright citizenship remains a guaranteed principle or becomes a conditional privilege shaped by parental status. This is not just a policy debate, it is a decision that could redefine how citizenship is understood for future generations. As the case reaches the U.S. Supreme Court, the focus now shifts from political debate to constitutional interpretation. The justices are tasked with answering one central question. Does the 14th Amendment guarantee citizenship to anyone born on U.S. soil, or are there limits hidden within its language? The phrase, "subject to the jurisdiction thereof," lies at the heart of the dispute. For decades, this clause has been interpreted broadly to include nearly all individuals born in the United States, with a few narrow exceptions such as children of foreign diplomats. However, the current argument, advanced by the administration of Donald Trump, is that this phrase should be read more restrictively. They contend that individuals who are in the country unlawfully or only temporarily are not fully subject to U.S. jurisdiction in the constitutional sense, and therefore their U.S.-born children should not automatically receive citizenship. On the opposing side, civil rights groups, including the American Civil Liberties Union, argue that this interpretation contradicts both historical precedent and the plain meaning of the Constitution. They point directly to the long-standing ruling in United States versus Wong Kim Ark, which affirmed that birth on U.S. soil is sufficient for citizenship regardless of parental nationality or immigration status. In their view, the phrase, "subject to the jurisdiction thereof," was never intended to exclude children of immigrants living in the country. Instead, it was meant to exclude a very narrow group, primarily foreign diplomats and others who are not fully under U.S. legal authority. This interpretation has guided citizenship law for more than a century and has been consistently applied across administrations of different political parties. The legal conflict is therefore not just about policy, but about constitutional interpretation and judicial precedent. If the Supreme Court chooses to adopt the administration's argument, it would effectively narrow the scope of the 14th Amendment and potentially overturn or limit the precedent established by Wong Kim Ark. Such a decision would signal that constitutional meanings can evolve significantly over time based on new interpretations. On the other hand, if the court rejects the argument, it would reinforce the stability of long-standing precedent and affirm that birthright citizenship remains a constitutional guarantee that cannot be altered by executive action alone. In either case, the ruling would clarify how much authority a president has when interpreting constitutional rights through executive orders. Another important aspect of this case is the broader political and institutional tension it represents. The Supreme Court is often seen as the final arbiter of constitutional disputes, but its decisions can have far-reaching consequences beyond the courtroom. A ruling in favor of the executive order could reshape immigration policy, influence future legislation, and potentially open the door for additional reinterpretations of constitutional rights. Conversely, a ruling against the order would reaffirm judicial consistency and limit the extent to which executive power can redefine established legal principles. The case also highlights the ongoing balance of power between the branches of government, executive, legislative, and judicial, and how each plays a role in shaping national policy. As arguments approach, both sides are preparing to present their strongest constitutional reasoning, historical evidence, and legal interpretations. The justices will be tasked with weighing not only the text of the Constitution, but also the implications of their decision for millions of people. This is not merely a technical legal question. It is a defining moment in constitutional law that could influence how citizenship is understood for generations. Whether the court chooses to uphold tradition or embrace a new interpretation, its decision will serve as a landmark ruling with lasting consequences for the nation's legal and social framework. As the nation awaits the final outcome from the U.S. Supreme Court, it is clear that this case extends far beyond a single executive order issued by Donald Trump. At its core, the dispute is about how the United States defines belonging in an era of increasing globalization and migration. The interpretation of the 14th Amendment has remained relatively stable for over a century, largely due to the precedent established in United States versus Wong Kim Ark. That stability has allowed generations of families, regardless of their immigration background, to build lives with a clear understanding of citizenship rules. However, this case introduces uncertainty, raising questions about whether long-standing constitutional interpretations can be revisited in response to modern political and social concerns. If the court upholds the executive order, the implications could be profound. Birthright citizenship, as it has traditionally been understood, would no longer be universally guaranteed. Instead, citizenship at birth could become conditional, depending on the legal status of a child's parents. This shift could lead to significant administrative challenges, as federal and state governments would need to determine eligibility based on parental documentation. It could also create legal ambiguity for families, particularly those with mixed or uncertain immigration status. Children born under such a system might face difficulties accessing education, healthcare, or legal identification, potentially creating a class of individuals whose citizenship status is unclear or disputed from birth. Over time, this could influence demographic patterns, social integration, and even economic participation across the country. On the other hand, if the Supreme Court rejects the administration's interpretation, it would reaffirm the traditional understanding of birthright citizenship and reinforce the principle that constitutional rights are not easily altered by executive action. Such a ruling would likely be seen as a continuation of established precedent, providing stability and clarity for millions of families living in the United States. It would also signal that changes to foundational constitutional interpretations require either a new amendment or a clear legislative process rather than unilateral policy shifts. For advocates of immigrant rights, including organizations like the American Civil Liberties Union, this outcome would represent a preservation of a key legal protection that has defined American citizenship for generations. Beyond the United States, the outcome of this case could also have global implications. Many countries look to U.S. legal standards as a reference point, especially on issues related to constitutional rights and immigration policy. A shift in how the U.S. interprets birthright citizenship could influence international debates about nationality laws and border policies. It could also affect how other nations approach the rights of children born to non-citizen parents within their own borders. In an interconnected world, legal changes in one major country often resonate beyond its borders, shaping discussions in policy circles, academic institutions, and international organizations. Ultimately, this case represents more than a legal disagreement. It is a defining moment in the ongoing evolution of American identity. The question of who is considered a citizen goes to the heart of what it means to belong to a nation built on both law and ideals. As the Supreme Court prepares to weigh its decision, the country stands at a crossroads between tradition and reinterpretation, stability and change. Whatever the outcome, the ruling will not only determine the fate of a specific policy, but will also leave a lasting mark on the constitutional landscape of the United States, influencing how future generations understand citizenship, equality, and the promise of America itself.